Is it just me, or does this whole process just take far too long to set up? So getting over here from the tube room and the walk and everything, too difficult. Anyway, made it eventually. It's a good solid shot of a largely empty place in the room. Did we get more than last week? It is 10, just about the same. About the same. Good job. Okay, as you guys are aware, you've all done all your assessment. Has anybody not done all of their assessment for the subject at this stage? Is everybody still having either tube presentations or particularly the test? I have fielded a couple of emails about the test in terms of getting feedback, and you'll find, for those that did get emails back from me, that those questions were intentionally very, very vague. I have talked to Jamie, and tomorrow we're going to go and follow up to see whether or not everybody who is eligible to do the test has done it, and then we'll release structured feedback for that. Okay, that's the true and correct answer for that. All right, so this is the last lecture that we have on judicial review. It's probably going to be a little shorter than some of the earlier ones. It's on the remedies that you can seek either at common law and or under the statute for judicial review. Now, one thing that I found in the previous tutorial was that there seems to be a general lack of understanding about what and how remedies work. And so in terms of judicial review, I did approach this particular part earlier in the semester, and I said, oh, look, we'll talk about it in very brief or simple terms. So the first few slides that I have here are actually a direct copy of the slides from, I believe it's week 3, where we've gone through and just talked briefly about what are the types of things you can get when you win an action in administrative law. So I'm going to go through each of these in a little bit more depth, and hopefully, I guess in terms of their form and function, it's something you guys should try to commit to your heads, because when people come and ask you guys about particular things that can and can't be done in relation to government decision making, the sort of scope and design of the remedies that you can get either under statutory framework, the ADJR and the JRA, under the common law or prerogative writs, in terms of the High Court, those are known as constitutional writs, and in equity. And to just know and understand how each of these operates from a functional perspective, really with the aim of being able to assist the particular person that you're advising as best you can. And so this is a recap from week 3. We talked about the 3 great prerogative writs. What does that mean? Those are the things that in ye old days you would go to a superior court and ask them to give you an order. And those orders fall under 3, I guess, categories, broad categories. You can either, if a decision's already been made, you can ask for that decision to be unmade, to be quashed in some way. That is the writ of Certiorari, and that applies, or that's the writ that you seek where a decision's been made, usually one you don't like very much, and you want to have the decision that's been made unmade, made void, rendered void ab initio, undone in some way. That's the first of the big 3. The second is prohibition. That is a writ where you go to the court and ask a decision maker to not make a decision or not do certain aspects of conduct in relation to an administrative function. That is prohibiting them from doing something. So it has to be done ahead of time. place before a decision's been made. And the third great prerogative writ is Mandamus. That is making them do something. And as you can imagine, there's a little bit more to it when you're making people, or even government bodies, do things, as opposed to undoing things they've already done, or stopping them from doing things in the first place. There's a little bit more to it. The hurdles are a little higher. And as we recall from the lecture about standing, at common law, the standing requirements are much narrower for Mandamus. So you have to be very directly affected by a particular decision or decision maker, lack of a decision, in order to seek some form of remedy. Now, the other thing to note is that these can also be argued together. Hey, you government body, you've made this decision. We want you to unmake it and then make a new one. So the two things are, I guess, can be argued together as part of that process. There's two writs that I talked about briefly. There's the writ of habeas corpus. That's where you go, get an order from a court demanding an executive officer bring the body before the court. It's also known as the greatest of all of the prerogative writs. It doesn't really happen as much as you might think, because it doesn't come up very often. In situations where a person is incarcerated, often that's done under a series of well-crafted, well-established statutory rules. Who knows what day is the worst day to be thrown in the watch house? What's the worst day of the week? Sean's got it. Friday night. Why is that? Because you've got to wait until Monday morning before the magistrate rocks up. And are they allowed to do that? Yes, because those are the structured statutory rules that we have in terms of incarcerating people for simple offences. That's why first thing on a Monday morning is not when you want to be in magistrate's court. It's very busy. Quo warranto is just a writ demanding somebody show by which office or which document they are doing a particular decision-making series of steps under. I believe that's abolished in Queensland, but it's still available under the High Court and the Federal Court. Okay, now for those lucky souls that have just passed through the equity subject, you would have learned about, and possibly some of you might have done a moot about, injunctions. And one of the key things to note is that injunction, as well as being a remedy for aspects of private law, it can also be a remedy in public law as well. And sometimes there can be some strategic advantages through seeking a remedy in equity over the prerogative writs. These can do with things like time frames. Sometimes you might be out of time for a particular, to seek a particular remedy under the ADJR or the JRA, and so you have to go through and look at the prerogative writs and or equitable remedies to seek some sort of result. You'll also find that these can be more readily applied to private bodies as well, possibly like student associations. Also note there that this idea of the declaration is not something that's really appeared in any other area, certainly from my memory as an undergraduate. It doesn't really appear very often, but it's quite an important aspect of administrative law in that you can go to the court and ask them to declare what the rights of the parties are. So it's almost like going to the court in advance. And because it's to do with and concerning future events, it's in its equitable jurisdiction. So the rules of equity apply. The clean hands doctrine and unreasonable delay and latches and so on. Anyway, that is a quick primer, and it's a recap from week 3 as to what the heck these things are on about. The key thing to note are the big 3: Certiorari, Mandamus, prohibition. Okay. Right. Oh, it's still not popped up. It'll pop up in a second. So when we're looking at the rules for certiorari and prohibition, these are often analysed together in terms of, and this was true of the standing requirements. Largely, the rules for quashing a decision that's been made or preventing a decision maker from making a decision, they're very much in alignment. And so the statements of law that apply to these, with the exception of timeframes, which I'll talk about a bit later, are very similar and different and distinct from Mandamus. That's construed a lot more narrowly and more rigorously because of the, I guess, the need to protect society, I suppose, from people getting government decision makers from doing things. Mandamus is trickier. Certiorari prohibition. This case, this London electricity case, is where Lord Atkins talks about the exercise of these writs, which are called orders these days in Queensland. So sometimes you'll hear the term an order, a mandatory order or a prohibitory order. The Queensland legislation has just mapped those out and given them different names. But just make note that there's three aspects to this. In terms of the examining how and where the particular the certiorari or prohibition can be applied, and that involves yes we can. So the first thing to note that Lord Atkins is talking about, and this is to do with whether or not a particular remedy is available. It's available whether it's to do with some form of, I guess, public legal authority, or it's got to intersect or relate to some form of public authority, where that particular authority has the duty to act judicially, and they act in excess of that. And those are the three necessary components, so those are elements of the Atkins rule in the London electricity case. I'll just talk about each of those in a little bit more detail, because one of the curious aspects about administrative law that you don't sort of get to until you've delved a little bit into cases is that some of the old case law you guys may have read when doing torts, contract, and possibly criminal law as well. We're reading some of these old cases, and the particular person petitioning the court is seeking a writ of certiorari, or writ of mandamus or prohibition. Right? And they're seeking this, usually a writ of certiorari, against a court. Now this, I have to just unpack this a little bit here. Because if we stop and think about this, when we're thinking about courts themselves, and certainly from the 20th century onwards, when we think about how we learn how the structure of the courts work, in terms of this hierarchy. If you have, I don't know, parking fine, you can go to the magistrate's court to fight it out in Queensland. If you don't like the decision of the magistrate, what can you do? Yeah, you can appeal. Anyone know the section? It's section 222. So they call these 222 appeals. Where do you appeal to? Chelsea said it quietly. It's to the district court. You don't like the decision of the magistrate court, go to the district court. You don't like the decision of the district court, where do you go? So you go to the Supreme Court of Appeal. So either if you've got a decision which is made in either the district or the Supreme Court, you don't like it, you can go, remember, only on questions of law, to the Court of Appeal. And if you don't like a decision from the Court of Appeal, what do you got to do then? Apply for leave to the High Court. Ask the High Court to hear it in their appellate jurisdiction. You can go through those steps and process, and those doing constitutional law, good old Pat Coleman, ex-JCU student, who did exactly that. Went through all of those processes to go through to the High Court. Now, one of the important things to note about this, these systems of appeal are statutory regimes. It says in the Justices Act, in section 222, if you don't like a decision from a magistrate, you can go to the district court. It says in the Commonwealth Judiciary Act, the High Court parties may apply for leave to appeal decisions from superior courts of the states and territories or federal courts and have those heard in the High Court. This system of appeal, it's not something that we commonly sort of really think about. We're just told it in first year. And there's the trouble about learning things in first year is you're told things, they go in your head and you're like, okay, cool, that's what it is. And it's not until later on where you actually have to go and re-examine this and realize that, oh, hang on, these rules, they've only been around for 100 years or so, these statutory mechanisms of appeal. It used to be in the olden days. If you didn't like a decision of a court, you could go to a superior court and seek a writ of certiorari. How does this work? Well, what you're trying to do is to quash the decision which is made by the judge in the inferior court or tribunal. So you're actually trying to quash that decision. So rather than this structured mechanism of appeals, you're actually going, as a citizen, going to the superior court, having the decision quashed of the inferior court. So when you guys are reading older cases, you will see this from time to time, where a person's seeking a writ and you're reading it. And particularly when you're in first year, you read these things and your eyes go glazed and you're just reading through it, okay, probably not important. And to be honest, probably isn't important. It's really just a technical or procedural thing. But it'll cast, when you're reading this now, I hope that you guys will interpret that with a little bit more sophisticated understanding of how and where those things sit. So that's the first thing to know. But now that these days that we have these structured statutory mechanisms for doing appeals, seeking a writ of certiorari against inferior courts isn't usually the mechanism that's used. Instead, we're really concerned about administrative bodies. And that kind of makes sense. That's the name of the subject. So, when we're looking at administrative bodies and whether they're acting or operating in this private sphere, I mean, this kind of makes sense. If you've got an organisation, and again, I'm not trying to pick on you guys, but it's a really good example, is the things like the student associations. Particularly the JCUSA is given powers. You're actually given statutory powers. For example, statutory powers to take money through the, what do you call it, the SAF fee, and powers to deliver that money out. Given a statutory power. Now, it's I guess, essentially a private body, I suppose. You can construe it as a private body. And that membership, I believe, is constrained to JC students. It is, that's a mandatory requirement. But they're still exercising public powers. You're doing things under, in this case, statutory frameworks that are giving you powers to go and do that. So as a result, a certiorari and prohibition can apply to those things in those situations. And note here this, the BBC case, ex parte Lavelle, so Lavelle's case, they were talking about employment contracts. Employment contracts very, very rarely are going to fall within the scope of public law. And if we kind of think about that, an employment contract is an inherently private thing. They can literally only be between, we use the phrase master-servant, I think is the expression you'll read when you're reading older cases. What's that, 83? Probably uses that language. That's inherently of a private nature. And so as a result, you're going to have a really hard time convincing a court to seek a writ of certiorari, quashing a decision to hire someone else instead of you, for example, or where the conditions or the terms of your particular employment contract have been breached and you've been terminated. You have a really hard time doing it under there. What's the correct avenue if you're the person aggrieved in that situation, where you believe that the termination hasn't been done according to law? It's breach of contract. you go through the courts and you seek a private remedy through the laws and rules of contract. Okay, Lane's case at the bottom, they're talking about privately established tribunals. Now you can have this. You can have, for example, industry bodies that go about determining disputes between members or between customers of members. Sometimes as a preliminary stage, sometimes as a final stage, in order to seek some form of remedy. And the courts have said in more recent times, it's 50 years ago, that those things are still susceptible to certiorari and prohibition. You can still get a writ against these boards and committees which are making decisions, even if those committees are essentially private. And so an example of that might be ALSA, the Australian Law Students Association, decision there to expel a particular student association for being naughty, getting too drunk on one of those conferences or whatever they do. So just make note that it can extend to that and things that are might otherwise have thought were private. So anyway, that's the first element of Atkins formulation in London Electricity. The second one thing that you'd need to note is that it has to involve or impact or affect rights in some way. The courts don't like doing things that are futile. You'll see this comes up a lot. There are exceptions. Sometimes, for example, trespass. You can seek a writ of trespass and get $1, or demonstrate that your rights have been infringed. But really here, they're looking at where there's some form of impact upon citizens. I mean citizens in the broad sense. That includes companies and not Australian citizens and so on, people within the realm. Now, how this operates in terms of the actual decision itself can be a little bit complex. And so an example here, a High Court case of Hot Holdings, that involved a mining tenement. And there, you guys, I don't know if has anybody here studied mining law or anything? It's absolutely boring as. It's probably the worst subject I've ever studied. I did not study it through an institution. I studied it through another one, and it was without doubt the most unpleasant experience. And I will not name that institution, but it was horrible. So if you're interested in that thing, go do a geology degree and work in the industry for a while, and then go back and do it. It seems to be the way those things operate. But anyway, used to be in Queensland, but haven't had them for a while. But they still have in Western Australia. They have what's called the Warden's Court. The Warden's Court is not actually a court. It's an administrative body. A warden or mining warden is the person that goes and does things like grant tenements to mining entities. And in this particular case, Hot Holdings, they basically opened up a particular tenement, and with the idea being the statute said, first in, first served. Not a problem. Except when they opened the registry that morning, there were 51 applications, or some absurd number, 40-something applications within the first hour for a particular tenement. And so the mining warden said, what are we going to do? We'll ballot that. We're going to go and we're going to ballot that. And so the court, there is trying to determine, well, if you're balloting something, does the particular decision, if it's gone to ballot, actually impact on you as a particular person? Essentially, the decision maker has gone and crafted or created a particular way of making a decision. Does this impact you? Yeah, probably. That is going to be sufficient in that case. In GrowCon, that was to do with the administration of contracts. And it turns out that an administrative body actually going and determining, in this case, I think it was part payments of construction combat contracts. You know how before I said you can't get certiorari usually against private bodies? Well, you can in situations where those contracts actually do impact, can impact others in, or it has some form of impact on them through the way that you're going and administering the contract itself. I really didn't explain that very well. If you have a contract, as they did in Grocon, that involved the regular decisions to pay certain amounts under the equivalent of BSIPA. Anybody here intending to get into construction law? Does anybody here like money? Because that's a real good way, if you're doing law, to go about doing it. Why? Everything is magnified by a few decimal places. That makes sense? Everything you're doing is magnified. I don't know whether the fees you charge out are magnified to decimal places, but nonetheless, the persons I've known who've gone into that, they've done all right. Drive better cars than me, although it's not saying much. And so here, though, you had an administrative body that is making decision involving contracts in terms of paying or not paying. And there they said, look, that is actually you're sufficiently impacting or affecting the rights, and you're really doing that in a public way. So it doesn't fall within that earlier case I talked about, where they said that private rights, contracts are usually private arrangements. And finally, Ainsworth's case. When decision makers, and we've talked about this in other areas too, when they're making decisions where there are preliminary steps and processes that you go through before you actually substantially change the rights of parties, usually those initial steps or processes don't sufficiently affect the rights of parties sufficient for them to seek a writ of certiorari. So if you're going through a series of steps before you reach a particular decision, the Noosa Shire Council case in the mid-90s was an example, where you go through steps and then the court identified, well, from about this point onwards, it does impact rights, but up until this point, it's a preliminary series of steps. Hey, we're investigating something to work out if a decision needs to be made. And in those situations, if you're still going through that preliminary step, the courts, won't say that this is sufficiently impacting your rights enough for you to bring or achieve a writ of certiorari. Okay, the third limb, which I kind of talked about just briefly before, is to do with this acting judicially. And that seems a little bit strange because in this day and age, we're talking about administrative decision makers. And really that's what that third element of that of Lord Aikins's requirements is. In the olden days, this acting judicially, they were really referring to courts. And it kind of makes sense. If we go back 300 years, you had justice of the peace and magistrates, people that you would go and seek things, and they were the ones who would go and do the orders. You didn't have the great regulatory frameworks that we have in this day and age. Our society is heavily regulated in 2018. But if you go back a couple of hundred years, and that wasn't really the case. This Wingfoot case, High Court case, they talked about you're going to fall within the ambit of this third element if you're doing something under statutory power, just by default. Doing something, you've got a statutory power to do something, you're going to be falling within this broad concept of acting judicially as part of that, and as such, you're going to meet those hurdles in terms of those requirements for getting the writ of certiorari or prohibition. All right. Okay, now there's some other limits. So as well as having to meet those requirements, and look, they're generally a pretty low bar in terms of decision-making situations and scenarios that we've had. I mean, for example, is something tied to a statute? Yeah, okay, you're going to satisfy that third element. However, and again, this is going back to this idea that originally certiorari was there to try and quash the decisions of inferior courts. All right, and one of the ways that they would do that is this error of law on the record. How did this work? Well, you would go and get a transcript of court proceedings. And if we go back 150 years ago, remember, there was no public transcript of courts. You had to literally send someone in there, have them write things down, or you go and pay somebody that's done that. These reporting series is from the 1800s. Now, one of the real problems of this, of course, is that, well, look, you could probably go through every single transcript and find some form of error. And so that this, as a result, in modern times, in contemporary times, the courts have said, no, transcripts of proceedings, all right, in terms of how things are recorded and written down, are just not going to be sufficient in order for that to count as being some form of error, in order to get us to try and quash that as a decision. So where you've got transcripts of proceedings, in post-Craig's case, they are not part of being on the record. The order that a court makes, that little document that lists the things that the court's doing, that's going to be on the record, but the actual transcript from the trial and so on is not going to be. There's a floodgates argument there as well. Okay, another thing to note is that if the particular decision and the results of the decision are done and dusted, and the effects can't really be undone, then you can't get certiorari. All right, this is a little bit tricky. Now, if we think about this, if the minister has made a decision, and that decision is to demolish your house, all right, and the decision has been made and then carried out, you're too late. Certiorari has happened. I'm sure there are other areas of law that you could seek some form of remedy under, but in terms of getting a writ of certiorari, once the matter has been resolved, you can't get that particular writ. This is largely a matter of, well, I guess, logic and common sense, if any of these things ever come up in any aspect of law. Okay, so that's the key things to note. London electricity, 3 aspects there and a few limits to the certiorari remedy. Okay, we'll talk about Mandamus. Mandamus is getting decision makers to do something, actually making them make a particular decision. And because this obviously involves cost in terms of the public purse, and it can impact, the rights of other citizens as well. I mean, I guess you could say, if you're getting the government to do something and it's going to cost them money, that's impacting the rights of all of other citizens as taxpayers. But there are still additional limits to that, and that comes from Chief Justice Griffith and Randall's case. And one of the things to note here is, while you can compel officers, administrators, to do things, all right, the really key thing to note is that you are not telling them what to do. There's the one takeaway from this. It's the decision maker is being told to make a decision, sure. But that does not mean that they're going to make the decision the way you want it. Those things are absolutely, that's just an absolute truism. Sure, you may have armed them with information and showed them the error of their ways in terms of how the decision's previously made, had the decision quashed, and led their hand down the true path towards usually the favourable result for you or your client. But strictly speaking, you're not telling them what to do. They are exercising their discretion. And it has to be a discretionary act. So if you're seeking a writ of mandamus, if it is something that they inherently can choose to do or not do something as part of it, you can't get a writ of mandamus. If the particular function is inherently discretionary, it is solely the administrator's decision to exercise their power, choose to exercise their power or not, that's not an error of law. There's no error of law if the empowering, in this case the empowering statute, says they have full discretion to do or not to do something. If they choose to not do something, there has to be some other error in them not doing that, not taking those steps to actually make them do it. If it's just wholly discretionary, the particular power, you can't get a writ of mandamus. Okay, so some things to note. We talked about mandamus when doing standing. Mandamus at common law has a much narrower standing requirement. You have to be directly impacted by the particular decision maker or lack of a decision maker's exercise of their discretion in order to seek a remedy. A couple of other things to note though, that Ozone Theatre's case, you're not going to get a writ of mandamus if you can get something else which is more convenient or satisfactory. That's the language they use. If another alternative writ or some other remedy, for example, damages and tort. In this day and age, breach of statute, malfeasance in public office, for example, or did you guys, when you're doing torts, did you learn about the anti-discrimination frameworks in terms of breach of statute? I've had them come up just a few times in community legal stuff. For example, it is unlawful to publicly racially discriminate or vilify someone. All right? It is unlawful in the narrower context of employment to discriminate on somebody on the basis of their gender, for example. These broad statutes that we have in place in Australia, how do they get to be there? Because we signed up to these treaties. And these treaties says, hey, you've got to take these things and enshrine them in your domestic legislation, which we've done. And essentially what they do is to create a new category of tort. So if a person does, racially vilify another person in public, then that person aggrieved in that situation gets a statutory right to sue. And in situations involving public law, if a party has a statutory right to seek some form of alternate remedy that is more appropriate than a writ of mandamus, then that is the path they have to go down, and the court won't grant this writ. That's how that operates. And often, again, you'll find that in particular areas of law where there is a statutory framework that a minister and all of the little officials and government officers are operating under, often those statutory frameworks will have mechanisms and remedies for breaches of the statute that they can seek. And so those are the more appropriate mechanism. Kind of like, again, when you do tort or contract law, these other areas, you have to learn the common law rules, but you'll find in practice, when you're actually going and seeking some form of remedy from your client, the Centrelink or the migration and so on, those are very carefully mapped out in the relevant statutes. It's just easier to do it that way. Okay, similar to Certiorari, but applied much, much, much more narrowly. It's very hard to get mandamus to private bodies. And this kind of makes sense. Imagine if and again, I'm thinking of the Law Student Society, it's quite a different thing if you've made a decision and somebody's able to seek a writ stopping that decision in some way. All right, so you're either stopping you from making a decision with prohibition, or undoing a decision that's been made. It's quite a different thing, actually compelling a person or body to go and do something, to actually make a decision. And this appears in other areas of law, specific performance, for example. You guys remember those rules and contracts? It's really, really hard to make people do things. You can't get rid of specific performance if somebody doesn't want to come and, I don't know, fix your house or wash your dog or what have you. You can never get specific performance for personal service. Similarly, you can't get, it's very, very hard to get mandamus where you've got the private rights or obligations that are being adjudicated about. Okay, and finally, and I just mentioned this earlier, to do with royal insurance. That's probably the best example here, where you've got wholly discretionary powers. Now, the royal insurance case involved one of the state's internal revenue, their payroll tax, I think it might have been their Victorian? Yes, Victorian Office of State Revenue, where they had basically they had charged the insurance company a bunch of tax. It turns out to be wrong. Right, they're wrong. They took too much money off them, $4 million or some amount. All right. And the insurance company, because of this, they went and got that money from their clients and customer base. Oh, look, hey, we needed to pay this. You're obliged under your policy of insurance to pay us this. So they did. All right, fine. Now, it turns out they've gone back and read the statute, and the state Victorian Office of State Revenue was wrong. They were actually wrong about how that particular thing was construed, so they had to repay the money. Or at least they didn't have to repay the money. It turns out the way the legislation was written says the commissioner may elect to refund the money. And there, was it Mason Court? Yeah, it would have been. So there you've got the Mason Court. And it seems really strange because we're thinking about and you guys know the different types of courts. The Mason Court was the one renowned for being the upholder of the rights of citizens against the government, against these bodies, giving rights to people. And it seems a little bit strange because here they ruled that wasn't a wholly discretionary power. All right, a writ of mandamus could be ordered in that situation because when that section may was actually read in the context of the Act, the whole point of this thing and the point of that section was to really regulate, overpayments. The purpose of the Act is to lawfully tax things in order to increase state revenue. It's not to just do a money grab when in situations where you're not allowed to. And so they read that section down, even though they talked about, look, if this was truly a discretionary power, and the minister could decide to do this or not do this, then in that situation, a writ of mandamus wouldn't be available. Okay, I'm going to just pause there for a few minutes. We'll take a few breaks. We're probably going to finish early, I would think. What are the numbers? Oh yeah, guys are still here. Land's not here. Quick, let's just do all the important stuff. Give it the exam answers while Lennon's not here. Sorry. All right, I think I've just hit the numbers up, and we'll do that at the end. I think it's probably the best way to do that. Okay, so we'll carry on, do the second half of the class. When I say half, third, quarter. One of the nice things about teaching this in the second semester is that for most of you, in your third year of a 4-year LLB, you would have just studied equity with the wonderful Tina Hoyer, who wins all of the awards for best teaching practice and so on. And the nice thing is, hopefully, you learn stuff and it's in your head. I don't know how true that is, and by the slightly awkward smirks that I'm seeing around the room, perhaps we need something of a little small piece of revision. But fundamentally, an injunction is an order by a court in its equitable jurisdiction. What is equity? It is the hat that the court wears when remedying or filling in the gaps between the common law rules or procedures. It fills in the gaps or remedies defects in the common law. And its function in public law is very, very similar to its function in private law. And you guys, as part of your equity moots last semester, you would have looked at, I believe, a defamation/invasion of privacy issue, where you had a particular party, Lena Game Meats, and those cases where they're trying to seek some form of injunction restraining somebody from doing something. And a couple of things to note about that. One of the very special things about equity, because it's doing things that the common law can't usually do, one of the things it can do is what's called an interlocutory injunction. That means you can rock up to a court, sometimes without even the other party there, so it can be ex parte, and in situations where there is going to be a grave injustice that's caused, you can ask the court to get an injunction stopping a person from doing something to stop this great harm or great injustice from happening in the first place. And if we think about this, and again, I'm hoping this is vaguely familiar to you guys, going and doing the interlocutory injunction where you have to rock up and you only have to have a minimal amount of information, but you've got to have sufficient evidence of a grave injustice. It has to be something big, something that requires the court to step out of the normal bounds of the common law rules of having the parties rock up to court and fighting the good fight. In order to do that's a pretty high bar, and the courts do not grant these things willy-nilly. And again, things like Lena Game Meats, they're not going to get an injunction restraining television people from showing a show. Look, the correct remedy in that situation is suffer the loss of reputation and sue afterwards. Sure, you're going to suffer some form of harm, but we have to weigh that up against the right for free speech, for example. And there's no invasion of privacy tort in Australia either. And again, the courts, I believe it's Justice Mason, maps these things out in that Castlemaine-Tui's case. For those doing constitutional law, this is not the actual Castlemaine-Tui's case that you'll study when you study interstate trade. It's the preliminary matter to that, involving the good old Alan Bond running the breweries into bankruptcy, and he wanted to get an injunction to stop the South Australian government from putting the whatever it was, 7 cents a can when they wanted to have their recycling regime. I heard a rumour that Queensland is going to be doing this next year. Is this a thing? Has this been in the news? Do you guys know anything about that? Because I had heard that it was New South Wales was going to bring it in, or Victoria, or some other jurisdiction other than South Australia, maybe WA. But it was news to me when somebody told me this, and so I've been telling my 7-year-old, quick, grab all those aluminium cans and we'll store them in the back shelf. We'll probably end up with this huge pile of cans and then find it'll never happen in Queensland. It'd just be sad. Because this happened in South Australia a long time ago. And so when you're studying constitutional law, you'll study a case which is also called Castlemaine Tooheys in South Australia, but it's the 1990 case. And there they're talking about interstate trade and such like, and whether things are proportional or reasonably well adapted to particular things. But here this was an earlier case where they were looking at injunctions. And they mapped out and said that, look, if you want to get an interlocutory injunction before this thing has been fully heard and all of the parties have the opportunity to present their evidence and fight it out and cross-examine and do those things, you've got to meet a pretty high bar, a high threshold. The amount of harm has to be grave. Okay, now, one of the nice things or useful things about injunctions, though, is that they have wide scope. Now, you may recall from equity, there's two broad types of injunctions. Remember what they are? You remember the two broad categories of injunctions? Making people do something and stopping them from doing something. Yeah, there you go. Got it. Remembered something. And so and again, the rules of equity will apply, and they apply. We don't want to create some form of injustice. We don't want to impact third parties. We won't grant these things if there is unreasonable delay. And a party, this is a great one, has to come to the courts of Chancery and ask for a remedy in equity with clean hands. Remember that? So doing naughty things in relation to that particular transactional matter can be problematic for your client if they want to seek a fast and easy remedy in equity or an injunction of some sort. But again, there's other flexible things you can do. You can be ex parte and you can get interlocutory injunctions on things as well. So if something needs to be done quickly before the matter can go, the full matter goes to court, then this is a pathway you can at least investigate. And look, at the end of the day, for you guys, most of you are third year, you've got another full year of uni, then you've got PLTs, then we probably have some form of work experience component. If you do end up working in this particular area, it's still probably for most of it's going to be a few years away. The main thing, or the main takeaways I really want you guys to take away from this subject are really the conceptual ideas and the strategies. When people come to you with challenges, with problems that involve government decision making, to actually recall, hey, this is a possibility, that's a possibility, this is a possibility. And then go away, pull out your old admin notes and realise that you've done things like I did as a young fella studying legal studies, where you go to the exam and the question's on murder, you open up your book that I've written, because it's an first ever open book exam, and I look and it's got murder, underline, fill in rest for homework, and then 2 or 3 blank pages, because I wasn't the best of students at high school. Anyway, the trick is trying to remember the basics so you know when these things come up that there is potential for some sort of remedy, and then go and research that. I'm not going to arm you with all of the information. You need to fill in this form and you need to do this and apply at this particular time. That's really going to be up to you guys as competent, well-rounded legal professionals at that stage. Okay. All right. That's enough of that. Holding my breath until the thing comes up. It's really, really slow. The click takes about 15 seconds to pop up. So anyway, declarations. They're a thing. A declaration is basically, in its equitable jurisdiction, you go to the court and say, can you tell me what my rights are? Or in relation to this matter, can you go through and read the statute and actually tell us what the rights of parties are? What are our pre-existing rights? And interestingly, this is the most common of all of the remedies that parties seek in administrative law. And the reason for that is government agencies will follow these things as a general rule. So if you go and you seek a declaration from the court in relation to your rights, in relation to a particular statutory regime, you get a declaration from the court, government departments and ministers generally go, oh, yeah, right, fair enough. We'll just do this, we'll do that. So it's important to note that declarations don't do anything. They don't compel parties to do things. So if you're seeking a some form of remedy again from a private body, and they go and the courts will declare what the rules, it's still not going to actually make the possibly stubborn members of the various golf clubs or student societies or such like actually go and do things. It's not coercive in nature. It's just mapping out what the rights of the parties are. And I think I've mentioned this when we talked about declarations for the standing lectures. They can pretty much do and map out any old thing. The courts have very, very wide discretion in their equitable jurisdiction to map out what the pre-existing rights of parties is. They can map these things out, create this document, and it does, strictly speaking, nothing. But government agencies follow them as a general rule. And another thing to note is that, and it's kind of sad, I think it was Ainsworth, Ainsworth's case. I made this point about remedies needing to actually be useful in some way. Declarations are actually an area where the court can have or create a declaration announcing what the rights of the parties were, even though it's not going to achieve any form of substantive justice. So what does that mean? It means that you can go to the court and demonstrate that your rights have been infringed in some way, even if you're not going to be able to get anything out of this. And what the court said, and again this was an Ainsworth's case, they said that, look, all we're going to do here is say that, look mate, you were right. They were wrong, you were right. You're not going to get any money. The government's not going to change any decisions. They may not change any parliament, or parliament's going to change these things, but look, we can declare that at that particular point in time, you were right. If that makes you feel better, good on you. They can and are willing to grant declarations in that scope. Now, Justice Galdron, this is in Enfeld, City of Einfeld's case, had a lovely, very long wall of text. And it's really to do with the relationship between the equitable remedies and the common law prerogative writs. And she said there, look, the two things are not the same, and they ought never be the same. The whole point of equity, remember, is to remedy defects in the common law. So if there are defects in prerogative writs, and if you've read anything about the history of administrative law, there are many remedies. There are many errors or defects in the way, particularly, that the prerogative writs are argued in courts. They are complicated. A lot of writing has been made on these things. And there's been a lot of effort by Parliament in the last sort of 30 or 40 years to try and simplify these things. But it's really important to note, and she noted it here alone, and with the majority, but speaking alone in this particular matter, that equity is not to be constrained. We want to keep these things open. We want to keep them wide. We want to actually allow things like standing to be wider. We want to allow the right to have equitable remedies, even in some situations against third parties. We want to allow those, in many ways, to fix the narrow and flexible and really technical mechanics of getting prerogative writs, getting common law writs from superior courts, which is hard, technical, and in many ways, you could argue, unjust. Sometimes people, and if you think about that, before you started this class, could you have described what a prerogative writ was? Some of you might. Most of you probably couldn't. And if you think about it, though, that's something that rich people with rich lawyers and barristers can go and do, because they can go and they're armed with this information. It is not something that you as a citizen, a non-lawyer, I mean, you guys are going to become lawyers, so that's going to be moot in a few years anyway, but it's not something you really know or think about. It's entrenched in horrible language. It's got lots of archaic rules. And even though we've got the ADJR and the JRA to try and make these things a little bit simpler, it's an area of law that lay people just don't know about. It's hard. Okay. Speaking of the ADJR and the JRA, they have very helpfully gone through the common law back in the 70s and tried to map things out. And so it's not by coincidence when you go and read through these things that the orders or the powers that the court is given under the ADJR and the JRA align with the prerogative writs. And they try to really mask some of the underlying complexity of these things. What's that? We've got S, yeah, talking about complexity. Minister of Immigration and Citizenship and SZJSS, because that's easy to remember. But really that's what these things are about. And so that because when we're doing stat interpretation, if there is more than one possible interpretation, we pick the one which is most in alignment with the will of Parliament. What was Parliament's intent? Parliament's intent with the ADJR and the JRA is to make the stuff simple. Map it out, make it clearer, make it less arcane and technical. So that's our list of remedies there. Okay, but the courts have, nonetheless, talked about the statutory regime. They've talked and they've analysed that. And they said, look, this is not all, love, happiness and sunshine. And so while it does give some scope, and wider scope, for people to bring judicial review and to do it in a much more structured way, and it does bypass all of the arcane requirements and some of the technical aspects, nonetheless, it actually doesn't give the court the power to do things and to broaden the scope of judicial review beyond really what Parliament intended. And John's, an Australian Securities Commission, there you had a person trying to argue as part of their application that other respondents ought to be joined to it. Hey, look, Your Honour, the ADJR is designed to streamline these things and to give parties more standing and to make it more accessible for everything. Therefore, we want to try and apply that to name all of these parties as respondents. And the court said, no, some of these people have no relation to the matter that you're doing. The purpose of the ADJRA, yeah, sure, it is to widen the scope of standing, but it's not to widen or give us the power to widen the ambit of administrative law and judicial review. And finally, and importantly for those that end up in this area, the ADJR and the remedies that you have here don't give scope for damages. So if you succeed and you get a remedy under the statute, you're not going to get a dollar reward. Sure, if say like in the payroll tax case, sure, if you win, you get your remedy, and your remedy is for the Department of State Revenue to repay you $4 million. You're getting something out of it, but you're not, strictly speaking, getting damages or a compensation amount under the regime. And that is something, and it seems really simple, and it literally is the last thing about stat remedies, to note that that particular fact is massive for you guys when you're dealing with lay people who want some sort of result. And people will say to you, oh, can't we just get them to just pay me? Or can't we just get some dollars from them? It's like, well, kind of, and that you get them to remake decisions or quash existing decisions, or stop them making decisions, which may have the flow-on effect of getting you dollars, but you're not applying for dollars as such under the ADJR. It's just fundamentally not what that regime is set up to do. As we know, there are other areas of law to bring actions under. It's always funny when you see me, who's one of the least practical people you'll ever meet in your life, starting to talk about practical matters in relation to law. One very, very important practical matter for those doing civil procedure last semester, most of you it'll be next year. You'll go through all of the mechanical aspects of filling in the right forms, doing things and lodging them and so on. One of the really critical important things that gets probably like at least half of all complaints that come to the law QLS and then goes to the what's the tribunal called? The Legal Services Commission, I think it is, the LAC in Queensland. The complaints about practitioners are where they have missed deadlines. Being tardy is not a great personal trait for being a legal practitioner. So it's important to note that the different remedies that you're seeking have different timeframes. And the most important one to note when dealing with government agencies in your own lives, and when your friends and family members come up to ask you, because they will, the most important one is 28 days. A lot of the statutory frameworks give aggrieved persons under that particular framework 28 days to do something about the decision, request reasons, or to lodge an appeal with the AAT, or to do something. That, in terms of, we were a stat judicial review, was also enshrined in the ADJR. You've got 28 days to go and do this. Now, it's a little bit tricky when you're trying to determine exactly when that period of time starts. And one of the important things to note is, and I might have mentioned this before, when they make a decision, one thing you can do is ask them to remake that decision informally or through the mechanics of that particular statutory framework they're operating under. And the decision to not remake the decision is a decision unto itself. So at the point in time, so assuming your friend or family member has told you about this and you've got 24 hours, that is I guess, the quick and easy way to go about doing these things. Please remake this decision. Why? Because that, in most circumstances, is going to reset that clock. Other things to note. Equity. Equity is flexible. The whole point of equity is to remedy defects in the common law. However, uncomfortably sitting with that principle is the equitable maxim: equity follows the law. That always seems, like when I was studying that always seemed clear as mud to me. Is that for you guys? You know what I'm talking about here? For those, most of you done equity. Equity follows law. In fact, Rachel might have taught you in contract as well. So that's that idea that if there's a statute that has a time frame for bringing an action, and again, Section 10 of the Limitation of Actions Act, for bringing an action in contract, tort, or quasi-contract. What's quasi-contract? Things involving equity. That has to be done within 6 years. All right, so, and again, when trying to seek some form of remedy, I wouldn't wait 5.5 years before doing this, because in equity, taking too long is going to stop you from being able to do that particular action. I talk about latches, I believe, is the old-fashioned way of saying that. Don't sit on your rights. High Court's got their own rules, and quite helpfully called the High Court rules. And they have 6 months for certiorari and 2 months for Mandamus. Again, construed narrowly. What about prohibition? What's the time frame for prohibition? I'll put it to you guys. What's the time frame for prohibition? Before it happens. There's no time frame. You just got to do it before the thing happens. Yeah. And that's right. So there's no formal time frame for doing that because you have to do it ahead of time. If it's already happened, that's when the clock starts. Federal court, reasonable time. And again, it's a lot of these things in the federal court and in the Queensland Supreme Court, you can seek leave of the court to have that extended. And to be honest, from what I've seen, it's just a couple of cases. It actually seems to be a pretty low bar. But don't push your luck. With all of these things as practitioners, you want to be as diligent and as vigilant and as not tardy as you possibly can. And finally, one very last slide. So where are we for time? Oh, yeah. You may have noticed that the case citations are a little bit weird in this. You know, when we talk about criminal matters, it's the Crown or the Queen against such and such. But there's quite a few of these administrative law cases where it's got Rex or Regina, and then it's got the V, and then it's got the minister's name, and then it's got ex parte, another person's name. And that's just a convention that they've had for quite a long time for matters of administrative law, because in theory, when you're rocking up to the court, it's almost like you're doing it on behalf of the Crown itself. You're asking the Crown to seek a remedy against some other body, being a ministry of some sort. So that's why these things always look a little quirky. So if you do see that, that is a judicial review action. And don't quote me on this because I haven't gone and checked, and I believe it's in the AGLC. I don't know whether it's against or and for the V in this part. I would be tempted to say and, but I actually genuinely don't know. So feel free, have a look through I believe it's in the AGLC, to have a quick look at that and report on it next week. Oh, just as a technical matter, you may have seen this phrase, order nisi. Nisi, Latin. You may or may not have seen that. It actually, almost certainly you've seen that phrase in earlier cases that you would have read about for other areas of law. An order nisi is an order of the court done usually as a preliminary stage where they list out the things that are going to happen. But there is a precondition. Essentially, it's a conditional order. Something else has to happen before this order comes into being. And often in administrative law, a party goes to court, gets an order nisi, and that says, you know, we compel the minister, the order says, we compel the minister to do this, this, and this, and this, after the hearings actually happened. So it's basically almost like an application process. You rock up to court, and it has to be through court, and again, this is when we're talking about standing, the preliminary matter of standing, it's often determined at that stage. You get the order, you say what you want, and then that goes to the relevant government department. They get their evidence, you go away, you get your evidence, and then you fight and you have the full hearing some stage later. And that, one of the things, if you win, is that the order nisi, the original order, is then converted, or the condition is now satisfied, and then it can be carried out. And I think I mentioned this earlier, declarations are quite a common mechanism for doing this because the government departments follow them. Because they follow them, practitioners have found that it is a useful mechanism to avoid the cost of actually going and getting a proper administrative, proper prerogative writ or a statutory order, making them do something. If you can get your rights, your position mapped out in advance, and you're right about it, so the court's actually mapped it out, said, oh, yeah, you're right, yeah. This has been made ultra vires, or yes, you are entitled to this, or yes, they needed to make a decision, then giving it to the relevant government department. Because by and large in Australia, the government department gets it and goes, yeah, sure, we'll let that one go to the keeper, and we'll just do what the particular order suggests that we have to do in relation to that. All right, I'm not having anything else to add for this particular area, but I will go through grade things, but I'll turn the recording off. So thanks, guys. I hope that was useful. And we'll see you next week.